of the nominee. We're also likely to hear speeches about the payroll tax cut, which expires at the end of the month. Democrats yesterday offered a plan to extend the tax cut and pay for it with the 1.9% surtax on people with annual incomes over $1 million. Now live coverage of the U.S. Senate on C-SPAN 2.
The Senate will come to order. The chaplain, Dr. Barry Black, will lead the Senate in prayer.
Let us pray. O God, who has blessed us abundantly with inner joy and an outer supply of all good things, we're grateful for your helping us in our poor attempts to do your will. Lord, forgive the things that keep us divided, the false pride that leads from unity. Give us a yearning for a life shaped and supported by a will better than our own. Guide our senators during today's labors. Help them know the strengthening joys of your Spirit. Keep them from being intimidated by the world's problems and threats, because you have overcome the world. We pray in your great name. Amen.
Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The clerk will read a communication to the Senate.
Guilty of quorum. Washington.
Clerk will call the no, clerk will read the communication to the Senate.
I'm going to read it. Washington, D.C., December 6, 2011. To the Senate. On the provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Jean Shaheen, a senator from the state of New Hampshire, to perform the duties of the chair. Son Daniel K. Inouye, President Pro Tempore.
Clerk will call the roll.
Mr. Akaka.
Majority Leader.
Following leader remarks, the Senate.
The Senate is in a quorum
I
call.
consent the quorum call be terminated.
Without objection.
Following leader remarks, the Senate will be in a period of morning business until 11 this morning. The majority will control the first half, Republicans control the first half. I would ask consent that the order be changed to allow both sides a half an hour.
Without objection.
Following morning business, Senate will be in executive session to consider the nomination of Caitlin Halligan to be a judge for the District of Columbia Circuit. At noon, there will be a cloture vote, and I ask, make sure that the consent that I just asked doesn't change that at all. There will be a little less time to debate that, but I think that will be sufficient. So at noon, there will be a cloture vote on Halligan. Following that vote, the Senate will recess until 2:15 this afternoon to allow for our weekly caucus meetings. I understand that S. 1944 at the desk and due for a second reading.
The clerk will read the title of the bill for a second time.
S. 1944, a bill to create jobs by providing payroll tax relief for middle-class families and businesses and for other purposes.
Madam President, I would object to any further proceedings with respect to this legislation.
Objection having been heard, the bill will be placed on the calendar under Rule 14.
Madam President.
The Republican Leader.
Yesterday, my friend, the Majority Leader, unveiled what he rather misleadingly referred to as a compromise on the payroll tax. I say it was mislead because we had to find out about it from reporters. This was not a compromise. This was nothing more than another bill designed to fail. So Democrats can have another week of fun and games on the Senate floor while tens of millions of working Americans go another week wondering whether they're going to see a smaller paycheck at the end of the year. Now, I've said I support this extension. I don't think working Americans should have to suffer any more than they already are for the President's failure to turn this jobs crisis around. Unfortunately, the Majority Leader has yet to introduce legislation that can actually pass the Senate or the House. And you would think that this is in the President's top priorities, and the Democratic leader of the Senate would put together a proposal that is designed to actually pass, but we haven't seen it yet. We all know what a successful bill would look like. So I hope the Majority Leader comes forward with a real proposal soon, because time is running out. It makes absolutely no sense at a moment when 14 million Americans are looking for jobs to raise taxes on the very people we're counting on to create them. That's why the Senate rejected the idea last week on a bipartisan basis. Look, the Democrats know as well as we do that this is a terrible idea. They've seen the same letters that I have. The National Association of Manufacturers says this tax hike would seriously impair the ability of their members to put unemployed Americans back to work. The Democrats know as well as I do that 4 out of 5 of those who'd be hit by this are business owners, people who create jobs. The only reason we even went through this exercise is because it obviously polls well. So this is what Washington has been reduced to: a President and a Senate that would rather spend their time doing cheap political theater than giving people the certainty that they want. What we need to do is to step back and realize that the only reason we're talking about a one-shot stimulus measure nearly 3 years into this presidency is because of the President's failure to turn this jobs crisis around. We need to get beyond the temporary fixes and start talking about fundamental tax reform that puts the American worker in charge of this recovery, not Washington. But for now, it's perfectly clear that the path to an accomplishment on this issue does not run through tax hikes. Yesterday, the President warned Congress to keep its word to the American people and, quote, "Don't raise taxes on them now," end quote. I'd just like to remind my colleagues the Republican plan is the only plan that meets the President's standard. The President just warned us, don't raise taxes on the American people. The proposal that we offered is the only one that meets that standard. So if our friends are serious about passing this extension of the payroll tax cut, they've got a choice. We can have an accomplishment, or we can have additional partisan show votes. Now, Madam President, on another matter, later this week, the Senate will vote on whether or not the new Consumer Financial Protection Bureau should move forward with a director before addressing concerns that have been raised about the Bureau's lack of transparency or accountability to the American people. I understand through press reports that the President plans to make a big push for this nominee to the CFPB. But let me tell you something the President hasn't done when it comes to this position. In the 7 months since 44 Republicans sent the President a letter outlining some very serious and very reasonable concerns about it, he hasn't done a thing to address these concerns. Not one thing. If he'd picked up the phone to talk these issues over with anybody in our conference, I haven't heard about it. If he's put some thought into how he could ensure the perfectly legitimate concerns we raised in that letter are addressed, he hasn't let us in on the game plan. Here's what we asked for in that letter, which now has been signed by 45 Republican senators, not 44, 45. All we asked for before we vote to confirm anybody to run the CFPB, regardless of their party affiliation, regardless of who the President is, are 3 clear, simple, common-sense reforms that would make sure that this new agency is accountable to the American people. First, replace the single director with a board of directors that would oversee the Bureau. Under the deeply flawed Dodd-Frank bill, the director of the CFPB, by design, is set to lead one of the least accountable and most powerful agencies in Washington. What we're saying is that no single person who's unaccountable to the American people should have that much power. We're asking for the same structure. We're asking for the same structure as the SEC, the CFTC, and the FDIC, the FTC, the NLRB, and the Consumer Product Safety Commission. The same structure we use any time we give unelected bureaucrats new powers that need to be checked to protect against abuse. Second, subject the Bureau to the congressional appropriations process. Subject this new CFPB to the congressional appropriations process. Currently, the CFPB is housed at the Federal Reserve and funded through a percentage of their annual budget, giving it a funding stream that is completely unique in government, entirely without a check from the American people, and making it one of the least transparent agencies in Washington. If you like the level of accountability over at the Fed, you'll love the CFPB. A journalist who wanted some information about the Fed's lending practices recently had to sue to find it out. This is information not even Congress could have gotten on its own. If you ask me, the American people should be getting more transparency out of this administration, not less. We don't need any more unelected, unaccountable czars in Washington. Number 3, we asked for a safety and soundness check for the prudential financial regulators who oversee the safety and soundness of financial institutions. This would help ensure that we're not inadvertently causing bank failures through excessive regulations. So our proposal would do nothing more than give congressional committees a proper level of oversight and accountability over this new bureau and ensure that its decisions were subject to the checks and balances that were meant to be inherent in our system, something we owe the American people. Everybody supports strong and effective consumer protection, but the CFPB in its current form cannot stand. In its current form, the CFPB could easily be used for political purposes at the expense of access to credit, job creation, economic growth, and financial stability. Now, what's needed is transparency and accountability. That's all we've asked for. and the President has done nothing to address these concerns. Instead, he's ignored these perfectly legitimate concerns, and now he's suddenly making a push to confirm his nominee because it fits some picture he wants to paint about who the good guys and the bad guys are here in Washington. So once again, he's used the Senate floor this week to stage a little political theater. He's setting up a vote he knows will fail so he can show up afterwards and say he's shocked. This is what passes as for leadership right now in the White House, and it's truly unfortunate. Look, we all believe Americans need access to financial products that aren't rigged against them. We just think that nobody should be above oversight, including the overseers. And we don't think that a bureau designed to watch Wall Street should have the ability to squeeze out hiring on Main Street. And frankly, the President's refusal to even consider our calls for oversight and transparency only serve to deepen our concerns about this agency. So once again, we'd like to call on the President to take these concerns seriously and work with us on achieving something positive together. Fact of the matter is, the CFPB needs a drastic overhaul before any nominee can be confirmed. This won't come as a surprise to anybody at the White House, and our doors remain open. Now, Madam President, on yet another topic, a number of things going on this week. Today, the Senate will vote on the nomination of Caitlin Halligan to the U.S. Court of Appeals for the D.C. Circuit. I'll be opposing this nominee, and I'd like to explain why. First and foremost is Ms. Halligan's record of advocacy for an activist view of the judiciary and a legal career that leads any reasonable person to conclude that she would bring that activism right onto the court. As I've said many times before, the proper role of a judge is that of an impartial arbiter who gives everybody a fair shake under the law as it exists. The role of a judge in our system, in other words, is to determine what the law says, not what they or anybody else wants it to say. Yet looking over Ms. Halligan's record, it's pretty clear that she doesn't share that view. In Ms. Halligan's view, the courts aren't so much a forum for the even-handed application of the law as a place where a judge can work out his or her own idea of what society should look like. As she herself once put it, the courts are a means to achieve, quote, social progress, end quote, with judges presumably writing the script. Well, my own view is that if the American people want to change the law, then they've got elected representatives to do that, and these elected representatives are accountable to them. This also happens to be how the founders intended it, and it's what the American people expect of their judges, fair, impartial arbiters. But that's not what they would get from a Judge Halligan. So how do we know this? Well, it's true that like many of the President's other judicial nominees, Ms. Halligan repudiated President Obama's own oft-stated empathy standard for choosing judges and disclaimed an activist bent in her confirmation hearings. But her record belies this now familiar confirmation conversion. Let's just take a quick look at her record to see what it does suggest about the kind of judge she'd be. On the Second Amendment, as Solicitor General of New York, Ms. Halligan advanced the dubious legal theory that those who make firearms should be liable to third parties for third parties who misuse them criminally. The state court in New York rejected the theory, noting that it had never recognized such a novel claim. Moreover, the court called what Ms. Halligan wanted to do to manufacturers of a legal product legally inappropriate. So let me say again, the New York Appellate Court termed Ms. Halligan's activist and novel legal theory to be, quote, legally inappropriate, end quote. Now, the Congress passed legislation on a wide bipartisan basis to stop these sorts of lawsuits because they were an abuse of the legal process. Undeterred, Ms. Halligan then chose to file an amicus brief in the Second Circuit Court of Appeals in another frivolous case against firearms manufacturers. Not surprisingly, she lost that case too. What about her views on enemy combatants? In 2005, the U.S. Supreme Court ruled in Hamdi versus Rumsfeld that the President has the legal authority to detain as enemy combatants individuals who were associated with al-Qaeda. Yet despite this ruling, Ms. Halligan's filed an amicus brief years after that, arguing the President did not possess this legal authority. On abortion, Ms. Halligan filed an amicus brief in the U.S. Supreme Court arguing that pro-life protesters had engaged in extortion within the meaning of federal law. The Supreme Court roundly rejected this theory 8-1. On immigration, Ms. Halligan chose to file an amicus brief in the Supreme Court arguing that the National Labor Relations Board should have the legal authority to grant back pay to illegal aliens, even though federal law prohibits illegal aliens from working in the United States in the first place. Fortunately, the court sided with the law and disagreed with Ms. Halligan on that legal theory, too. The point here is that even in cases where the law is perfectly clear, or the courts have already spoken, including the Supreme Court, Ms. Halligan chose to get involved anyway, using arguments that had already been rejected either by the courts, the legislature, or in the case of frivolous claims against gun manufacturers, by both. In other words, Ms. Halligan has time and time again sought to push her own views over and above those of the courts or those of the people as reflected in the law. Ms. Halligan's record strongly suggests that she wouldn't view a seat on the U.S. Appeals Court as an opportunity to adjudicate, even-handedly, disputes between parties based on the law, but instead as an opportunity to put her thumb on the scale in favor of whatever individual or group cause she happens to believe in. So, Madam President, we shouldn't be putting these kinds of activists on the bench. I have nothing against the nominee personally. I just believe, as I think most Americans do, that we should be putting people on the bench who are committed to an even-handed interpretation of the law, so everyone who walks into a courtroom knows he or she will have a fair shake. In my view, Ms. Halligan is not such a nominee. On the contrary, based on her record, her past statements, I think she would use the court to put her activist judicial philosophy into practice, and for that reason alone, she shouldn't be confirmed. So I'll be voting against cloture on this nomination, and I would urge my colleagues to do the same. I yield the floor.
The senator from Illinois.
Just the evidence of quorum.
Clerk will call the roll.
Mr. Akaka.
Madam
Majority Leader.
Ask consent to call the quorum be terminated.
Without objection.
Would the chair announce morning business, please?
Under the previous order, the leadership time is reserved. Under the previous order, the Senate will now be in a period of morning business for 1 hour, with senators permitted to speak therein for up to 10 minutes each, with the time equally divided and controlled between the two leaders or their designees, with the majority controlling the first half and the Republicans controlling the final half.
Madam President, I move to proceed to executive session to consider calendar number 413. I sent a cloture motion to the desk. In fact, it is at the desk.
The clerk will report.
Nomination, Bureau of Consumer Financial Protection. Richard Cordray of Ohio to be director. Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Richard Cordray of Ohio to be director, Bureau of Consumer Financial Protection, signed by 18 senators as follows: Reed of Nevada, Lieberman, Bingaman, Murray, Leahy, Conrad, Whitehouse, Reed of Rhode Island, Cardin, Boxer, Franken, Baucus, Durbin, Menendez, Tester, Brown of Ohio, Harkin, and Johnson of South Dakota.
I ask consent the mandatory quorum under Rule 22 be waived.
Without objection.
I now ask consent that we resume legislative session.
Without objection.
Note the absence of quorum.
Clerk will call the roll.
Mr. Akaka.
President,
Senator from Illinois.
ask consent the quorum call be suspended.
Without objection.
And, Madam President, can you notify me what stage we are in the proceedings?
The clerk will call the roll. Mr. Akaka.
President, ask consent the quorum call be suspended. And, Madam President, can you notify me what stage we are in the proceedings? President, ask consent the quorum call be suspended.
Without objection. There are 28 and a half minutes left to the majority in morning business, followed by 30 minutes for the minority in morning business.
Thank you, Madam President. I'd like to speak in morning business, and I'd like to respond to several things said by the Republican leader of the Senate. The first relates to Caitlin Halligan, who is the nominee to serve on the D.C. Circuit Court. The D.C. Circuit Court is the appellate court in the District of Columbia, which I would argue that next to the U.S. Supreme Court is one of our most important. The decisions of government are often sent to this court for review. At the current time, there are 8 who are sitting on that court and 3 vacancies. And of the 8 who are on the court, 5 are Republican appointments. So it is clear that any effort now to bring a new nominee to the court may tip that political balance. And I'm afraid that has a lot more to do with the fate of Caitlin Halligan than anything that's been said on the floor of the Senate this morning. It's mystifying to me that the Senate Republicans would filibuster her nomination. She's extraordinarily well qualified. She served for 7 years as the Solicitor General for the state of New York, currently serves as General Counsel for the New York County District Attorney's Office. She has argued 5 cases before the United States Supreme Court, served as counsel of record in dozens of other cases before that court. The American Bar Association looked at the qualifications of Caitlin Halligan, and here's what they said. She is unanimously well qualified to serve in this position. And Ms. Halligan's legal views are well within the judicial mainstream. She's received widespread support from across the political spectrum. What I've heard this morning from the Republican leader are isolated examples of cases that she may have argued. But he certainly doesn't speak to the fact that the National District Attorneys Association, the district attorneys from the state of New York, including Republicans, Derek Champagne, Daniel Donovan, William Fitzpatrick, James Ream, and Scott Burns, have all publicly endorsed her nomination. Raymond Kelly, police commissioner for the city of New York, Robert Morgenthau, one of the most respected district attorneys who ever served in this country, served in New York County for 34 years and endorses her. The New York Association of Chiefs of Police, the New York State Sheriff's Association. When you listen to these endorsements and wonder, is that the same woman that the Senate Republican leader just questioned as to whether she was serious about stopping terrorism? I listen to some of these things and I wonder how people of her quality would ever consider putting their name in nomination. That there would be suggestions on the Senate floor that perhaps she's not as strong as she should be in keeping America safe. There is simply nothing in the background of Caitlin Halligan that suggests that we have any extraordinary circumstances that warrant the defeat of the cloture motion on her nomination. A moment in history, please. When there was a suggestion of filibustering judicial nominations years ago, and the so-called nuclear option was being discussed, a gang of 14, a bipartisan group of senators, came up and said, unless there are extraordinary circumstances, we should vote on these nominees on the floor. There are no extraordinary circumstances in the case of Caitlin Halligan. The only thing that's extraordinary is how many people from different walks of life have endorsed her candidacy and the American Bar Association finding her unanimously well qualified. There are no legitimate questions about her competence, ethics, temperament, or ideology. All she's done throughout her career is serve as an excellent lawyer on behalf of her client. The Republican arguments against Ms. Halligan's nomination boil down to just 2. First, it doesn't really matter if there are vacancies on the D.C. Circuit, and in fact, in the past, they have argued to fill those same vacancies when they had an opportunity to install Republicans. Their second argument, Republicans are not happy with how certain nominees were treated years ago, and they see no problem taking out their unhappiness on this nominee. This is a dangerous path, Madam President. I believe our country needs excellent judges. Time and again, in your state of New Hampshire and my state of Illinois, you go to people who are sitting on the bench in a state court or in private practice and ask them if they would consider serving their nation on the federal court. They know that it's a big decision, whether they're going to change a career, but they know just as well that by submitting their name to the process, they are submitting or subjecting themselves to criticism which many people just don't care to withstand. In this case, the criticism against Caitlin Halligan is baseless. If judicial nominees cannot be considered fairly by the Senate on their own merits, good lawyers are simply going to stop putting their name into the process for consideration, and our country will suffer as a result. We should give Ms. Halligan an up or down vote on her merits, and on that standard, she should clearly be confirmed. Madam President, I ask that the next statement I'm about to make be placed in a separate part of the record.
Without objection.
I come to the floor today, Madam President, with a sad story for my colleagues. On the day after Thanksgiving, a young man named Joaquin Luna committed suicide in the town of Mission, Texas. This is a picture of Joaquin Luna with his mother. A handsome young man, full of promise. He took his own life on the day after Thanksgiving. He was a senior at Juarez Lincoln High School, where he was a straight-A student in Mission, Texas. He had a passion for architecture. In fact, he designed the home where his family lives. He was an accomplished musician, played guitar in his church choir. His family said he loved helping his neighbors with their landscaping, and he always had a smile on his face. Joaquin Luna dreamed of becoming an engineer. He'd been accepted into a number of excellent schools, including Rice University and Texas A&M. But Joaquin Luna was struggling with a problem which most American kids don't even imagine. You see, Joaquin was brought to the United States of America when he was 6 months old by his parents. He came here as a baby, lived his entire life in the United States, and was undocumented. Because of his immigration status, Joaquin Luna was unable to obtain financial aid to attend the universities that accepted him. He was unable to find a legitimate job. Joaquin's brother said his world just closed. He saw that everything he was doing was just for nothing. He was never going to be able to succeed. Joaquin's death is still under investigation, so I don't want to jump to any conclusions about why this tragedy took place. But I felt it was important to come to the floor today to pay tribute to this young man's all too brief life and to deliver a message to other young people like Joaquin Luna. There are tens of thousands of young people in this country facing the same challenge as Joaquin. They were brought to the United States as children. They grew up every single day, just as we did a few moments ago in the United States Senate, pledging allegiance to the only flag they've ever known, our American flag. They would sing the only national anthem they ever knew. It wasn't their decision to come to America. Certainly Joaquin didn't make any decision at the age of 6 months. But America was their home. And for tens of thousands of others in his status, America is their home and their future. But they're undocumented, and their future's uncertain. I have a message today for all of the young people like Joaquin. Don't give up hope. Keep your dreams alive. America is a generous and caring country. We can and we will find a way, a fair and just way, to give you a chance to be part of our nation's future. If you or someone you know is feeling hopeless because of the failure of the DREAM Act to pass in the United States Senate, there are people available to help and talk to you. You can call the National Suicide Prevention Lifeline. The number is 1-800-273-TALK. That's 1-800-273-8255. Today, my thoughts and prayers are with Joaquin Luna's family. I want to send them my sympathy and condolence and assure them that I will honor his memory by continuing to fight for all the young people in America who are just like Joaquin. Madam President, I never dreamed 10 years ago when I introduced the DREAM Act that I'd be standing on this floor 10 years later with that bill still not enacted into law. Time and again, we've had a majority vote in the United States Senate stopped by a Republican filibuster. Time and again, we have brought this issue to the floor and argued the cases of young people just like Joaquin Luna. We are only asking that they be given a chance to earn their way to legal status. That's it. They have to graduate high school. They can't have any serious criminal issues. They have to be willing to either serve 2 years in the military or graduate from college. Those requirements say that they have to be people who are determined to make America a better place. We just have a debate going on now about bringing in talented people from all over the world to work in the United States. Think about that. We're going to bend the immigration laws so that more talented graduates in other countries can come to our country and help build it into a better nation, creating more jobs and opportunity. At the same time as that's being proposed, we are saying to tens of thousands like Joaquin Luna, there's no place for you in America because your parents brought you here when you were a child. Therefore, you are forever banished from being part of America's future. That is a cruel outcome and one that we shouldn't accept as Americans. This is a great and caring nation, and it is a nation of immigrants. Madam President, 100 years ago, in 1911, a ship arrived in Baltimore, Maryland. A woman walked down the stairs, 2 little children by her side and a baby in her arms. She didn't speak a word of English. She came from Lithuania. She was bringing her children to America and trying to find how to get from Baltimore, Maryland to East St. Louis, Illinois, where my grandfather lived. He was there waiting for her, had a job in a place that they could call home. I don't know how she possibly made it, but she did. That baby in her arms, that 2-year-old infant, was my mother. I'm a first-generation American. I have the honor of serving in this United States Senate. I don't know if my mom was legal or not legal. Later in life, after she was married and had 2 children, she became a naturalized citizen. Upstairs in my office, her naturalization certificate is right behind my desk as a reminder about who I am. That's my story. That's the story of many families in America. It's the story of America. If we cannot open our arms and our hearts to those who will come here and work hard to make this a stronger nation, we will have lost one of the core elements of America's strength and America's future. We are great in our diversity. We are great in the fact that so many people are willing to work hard to come to this nation and make it a better place to live. Sadly, Joaquin Luna won't be part of America's future, but his story, I hope, will inspire others to step up and speak up for those who are promoting the DREAM Act. I want to bring this to the floor again. I want to pass it. I want to make sure that the hopelessness and despair that many young people feel is replaced by the hopeful belief that if they will continue to work hard in their lives and continue to be dedicated to America, they can make this a better and stronger nation. Madam President, in the honor of memory of Joaquin Luna, I ask my colleagues to reconsider their position and join us in passing the DREAM Act. Madam President, the last statement I'd like to make I'd ask be put in a separate place in the record.
Without objection.
Madam President, there was a question raised this morning by the Republican leader about where we stand in the closing 2 weeks before the holiday recess. We have a lot of important issues left. One of the most important is the payroll tax cut. Here's what it means. If you have a job in Illinois, an average job in Illinois, that pays about $50,000 a year, currently you have a break on your payroll taxes that are collected, about 2%. So what it means for those families is that they are able to have an additional $125 to $150 a month to spend. For some members of the United States Senate and the House of Representatives, $125 a month might not make much of a difference. But for a lot of families struggling from paycheck to paycheck, $125 can make a big difference. When gasoline prices go through the roof, you can fill that gas tank on your car or your pickup truck and make it to work. You might have a little extra money left for a utility bill when the natural gas prices and oil prices go up during the course of a cold winter. You might be able to afford some Christmas gifts for your kids, maybe even some clothes for them to go to school, a warm jacket for cold weather. $125 is important. If we don't act and act before we leave at Christmas, as of January 1st, that payroll tax will go up 2% on working Americans, and they will have less money to spend. As they spend less money, our economy struggles. When they buy things, goods and services, it creates more economic activity in businesses small and large and creates profitability and jobs, job opportunities we desperately need with our high unemployment. Now, we've taken a position with Senator Bob Casey's amendment here when it comes to the payroll tax cut that it is not unreasonable to ask that the wealthiest people in America, the top 1% in America, pay a little bit more in taxes so that we don't add to our deficit with this payroll tax cut. There were times in the past, as the President noted yesterday, when the Republicans actually argued you never have to pay for a payroll cut, a tax cut or a payroll tax cut. Now they've taken a different position. It has to be paid for. Well, we do pay for it. We pay for it with the surtax on millionaires. Unfortunately, some Republicans oppose that. Senator Kyl said yesterday on the floor in a statement relative to an exchange we had that it's hard to say that the rich are not paying taxes. Madam President, I'm not arguing that point. They are paying taxes. But frankly, under our system of government, with a progressive tax system, those who are well off, members of Congress and the United States Senate, and those with high salaries should pay more than those who are struggling from paycheck to paycheck. The people we are talking about, the top 1% wage earners in America, have an average annual income in 2013 of $1.4 million a year. $1.4 million a year. By my calculation, that is a paycheck of $28,000 a week. To say that those people can't afford to pay a little more in taxes is hard for most families to understand. It's hard for me to understand. The Bush tax cuts, incidentally, which the Republicans support, have been very generous to these people. Those in the top 1% making more than $1.4 million a year are going to see a tax cut in the year 2013 of $68,000. A tax cut at a time when we have federal deficits and needs in our country to get beyond this recession. These people in the top 1% control almost 25% of the income in America. 1% of the population, more than 25% of the income. That's up from 12% just 25 years ago. They control 40% of all the wealth in the United States. They are comfortable. In 1986, they only controlled 33%. In fact, we can see in the last 25 years, the wealthy in America have become even more comfortable. And to ask them to make even a small sacrifice for the good of this nation is not unreasonable. Senator McConnell came to the floor and suggested that what we're dealing with on the floor here is political showmanship. Well, last week we went beyond showmanship and we actually called a vote. We had a proposal, Senator Casey's proposal, to reinstitute this payroll tax cut, pay for it, as I mentioned, with a surtax on the wealthiest people in America. At the end of the day, out of 53 Democratic senators, 50 voted yes, and 1 Republican senator joined us. We had 51 votes in favor. It took 60 votes to pass, so it didn't prevail. Then Senator McConnell had his chance. He brought to the floor the Republican alternative. They would extend the payroll tax cut by eliminating jobs, over 200,000 jobs in the federal government, at a time when, frankly, we need more workers in veterans hospitals, and we need more people working on medical research at the National Institute of Health, and we need more involved in law enforcement to keep America safe. But Senator McConnell said the way to pay for any tax cut for working families is to eliminate federal jobs. They called it for a vote, Madam President. As you and I both know, there are 47 Republican senators on the floor. So how did the vote turn out when the Republicans called their proposal to extend the payroll tax cut? If I'm not mistaken, only 20 Republican senators voted for that proposal. In fact, Senator McConnell was the only member of the Senate Republican leadership who voted for the proposal. So you have to ask, when it comes to the competition of ideas, who won that exchange? The answer is no one won. Because at the end of the day, we did not extend the payroll tax cut. Back home in Chicago this last week, I had a press conference with a lady, single mom, 3 kids, struggling with 3 jobs with an annual income, combined income of less than $25,000 a year. I can't imagine how she gets by. But she said that $50 more a month, and that's what the payroll tax cut means to her, would be significant. $50. That's how close so many people live to the edge. It's time for us, in the closing days of the session before Christmas, to reach a bipartisan agreement, to make sure the payroll tax cut's extended, to make sure that the unemployment benefits that are needed so desperately by so many people out of work are there to help them and their families. The only way we can achieve that is in a bipartisan agreement. We now know that the notion of just cutting away at federal jobs has been rejected soundly, even by the Republican side of the aisle. Let us come to a reasonable conclusion of how to pay for this in a manner that doesn't add to unemployment, but adds more jobs to the American economy, something which most Americans agree should be our highest priority. Madam President, I yield the floor and suggest the absence of quorum.
Clerk will call the roll. Mr. Falco.
Madam President,
Senator from Iowa.
I ask that the calling of the quorum be suspended.
Without objection.
Soon we will be taking up the nomination of Caitlin Halligan to the D.C. District Court. I oppose the nomination, so this is why the nomination should not be confirmed. Nominations to the D.C. Circuit deserve special scrutiny. The Court of Appeals D.C. Circuit hears cases affecting all Americans. This court frequently is the last stop for cases involving federal statutes and regulations. Many view this court as second in importance only to our Supreme Court. As we all know, judges who sit on the D.C. Circuit are frequently considered for the Supreme Court. So there's a lot at stake with any nominee appointed to the Circuit Court, D.C. Circuit. Ms. Halligan has an activist record. There are additional concerns regarding her judicial philosophy and her approach to interpreting the Constitution. The Second Amendment, for instance. In 2003, Ms. Halligan gave a speech where she discussed her role in suing gun manufacturers for criminal acts committed with handguns. At the time, Congress was debating the Protection of Lawful Commerce in Arms Act, or as most of us called it at the time, the Gun Liability Bill. Those lawsuits, of course, were based on meritless legal theories and were specifically designed to drive drug gun manufacturers out of business. As it turns out, while many of us were fighting here in Congress to stop these nuisance lawsuits, Ms. Halligan was pursuing this precise type of litigation based on the same bogus legal theories on behalf of the state of New York. In New York versus Storm, Ms. Halligan argued that gun manufacturers contributed to a public nuisance of illegal handguns in the state. Therefore, she argued that gun manufacturers should be liable for criminal conduct of third parties. The New York Appellate Court, however, explicitly rejected that theory. The court explained that it had, quote, never recognized the common law public nuisance cause of action, end of quote, that Ms. Halligan had advanced. Moreover, the court correctly concluded that, quote, the legislative and executive branches are better suited to address the societal problems concerning the already heavily regulated commercial activity at issue, end of quote. While we were debating the gun liability bill then, Ms. Halligan delivered a speech where she expressed her strong opposition to that legislation. She opposed it because it would stop the type of lawsuits that she was pursuing. She said, quote, if enacted, this legislation would nullify lawsuits brought by nearly 30 cities and counties, including one filed by my office, as well as scores of lawsuits brought by individual victims or groups harmed by gun violence. Such an action would likely cut off at the pass any attempt by states to find solutions through the legal system or their own legislatures that might reduce gun crime or promote greater responsibility among gun dealers, end of the quote of Ms. Halligan. Later in that same speech, she expressed her view of law and legal system. She said, quote, "Courts are the special friend of liberty. Time and again, we have seen how the dynamics of our rule of law enables enviable social progress and mobility," end of quote. Now, this statement is very troubling, especially as it relates to the nuisance lawsuits against gun manufacturers. Those lawsuits are a prime example of how activists for the far left try to use the courts to effect social policy changes that they are somehow unable or unwilling to fight to achieve through the ballot box. That is why I believe those lawsuits represent not only bad policy, but more broadly, an activist approach to the law. I am also concerned about Ms. Halligan's view on the war on terror and the detention of enemy combatants. This is especially troubling because Ms. Halligan is a nominee for the D.C. Court, where we know a lot of these issues are often heard. In 2004, Ms. Halligan was a member of the New York City Bar Association that published a report entitled, quote, "The Indefinite Detention of Enemy Combatants and National Security in the Context of the War on Terror," end quote. That report argued there were constitutional concerns with the detention of terrorists in military custody. It also argued vigorously against trying enemy combatants in military tribunals. Instead, it argued in favor of trying terrorists in civilian Article III courts. Now, as I said, Ms. Halligan is listed as one of the authors of that report. But when it came to testify at her hearing, Ms. Halligan tried to distance herself from that report. She testified that she did not become aware of the report until 2010. In a follow-up letter after her hearing, Ms. Halligan did concede that, quote, "It is quite possible that a draft of report was sent to me," end of quote, but she could not recall reading the report. I recognize that memories fade over time, but as I assess her testimony, I think it is noteworthy that at least 4 other members of the committee abstained from the final report. Ms. Halligan did not. I would also point out that she co-authored an amicus brief before the Supreme Court in 2009 case of Al-Mari. Ms. Halligan's brief in that case took a position similar to the 2004 report with respect to military detention of terrorists. In that case, she argued that the authorization for use of military force law did not authorize the seizure and indefinite military detention of a lawful permanent resident alien who conspired with al-Qaeda to execute terror attacks on our country. The fact that Ms. Halligan co-authored this brief pro bono suggests to me that she supported the conclusions reached by the 2004 report, and again, this issue is particularly troublesome for a nominee to the D.C. Circuit, where, as I've already said, many of these questions are heard. There are a number of other aspects of the record concerns me. Most, for instance, she authored an informal opinion on behalf of Attorney General Spitzer regarding New York's domestic relations law. That opinion invoked a theory of an evolving constitution. As New York Solicitor General, Ms. Halligan was responsible for recommending to the Attorney General that the state intervene in several high-profile Supreme Court cases. She filed amicus briefs that consistently took activist positions on controversial issues such as abortion, affirmative action, immigration, and federalism. I'll give you some instances. In Scheidler versus National Organization for Women, she supported Now's claim that pro-life groups had engaged in extortion. In a twin affirmative action case of Grutter and in Grutz, She argued that the use of race in college and law school admissions was not only appropriate, but also constitutional. In Hoffman Plastics Compound versus NLRB, she argued that the NLRB should have the authority to grant back pay to illegal aliens, even though federal law prohibited illegal aliens from working in the United States. Ms. Halligan represented New York and Massachusetts versus EPA, where a number of states argued that Clean Air Act authorized and required the EPA to regulate automobile emissions and other greenhouse gases associated with climate change. These are just some of the many concerns regarding the nominee's judicial philosophy and her approach to constitutional interpretation. Based on her record, I do not believe she will be able to put aside her long record of liberal advocacy and be a fair and impartial jurist. Yesterday, before the votes on the judicial nomination that we confirmed, I made a few remarks regarding the history of this seat. So I would briefly review again the approach that I've been arguing for more than a decade and had the support of other senators, that there are too many seats and it's an underworked circuit. It may come as a surprise to some, but this seat has been vacant for over 6 years. It became vacant in September 2005 when John Roberts was elevated to the Chief Justice of our Supreme Court. But it has not been without a nominee for all that time. In June of 2006, President Bush nominated an eminently qualified individual for this seat, Peter Keisler. Mr. Keisler was widely lauded as a consensus bipartisan nominee. His distinguished record of public service included service as acting Attorney General. Despite his broad bipartisan support and qualifications, Mr. Keisler waited 918 days for a committee vote that never came. But Mr. Keisler was not the only one of President Bush's nominees to the D.C. Circuit to receive a heightened level of scrutiny. In fact, when President Bush was president, his nominee to the D.C. Circuit did not simply receive heightened scrutiny, but were subjected to every conceivable form of obstruction. Those of us who were here remember those debates very well. Estrada, Roberts, Griffith, Kavanaugh, Keisler, and Brown. All of these nominees had difficult and lengthy processes. This included delays, multiple filibusters, multiple hearings, boycotting markups so that we would not have a quorum to vote on their confirmation, including even invoking the 2-hour rule during committee markups and other forms of obstruction. I have not suggested that we repeat all the tactics used by the other side employed during a Republican administration. I do believe, however, that it is important to remind my colleagues of the precedents the other side established for nominees to this circuit. There's one other relevant fact that I would like to briefly discuss in connection with this vote, and that is the workload of the D.C. Circuit. And it gets back to what I've already referred to. It's an underworked, compared to other circuits, an underworked circuit. When Peter Keisler was nominated to the same seat, my friend on the other side objected to even holding a hearing for the nominee based upon concerns about the workload of the D.C. Circuit. So here's something we tend to agree on that's gone by the wayside now that we have a nominee from this president of the other party for this same seat. During Mr. Keisler's hearing, one of my Democrat colleagues summarized the threshold concerns. He said, quote, "Here are the questions that just loom out there. 1, why are we proceeding so fast here? 2, is there a genuine need to fill a seat? 3, has the workload of the D.C. Circuit not gone down? 4, should taxpayers be burdened with the cost of filling that seat? Does it not make sense, given the passion with which arguments were made only a few years ago, to examine these issues before we proceed?" So we have 5 very important questions that are applicable today from a member from the other side of the aisle. But I have not heard these same concerns expressed by my friends on the other side with respect to Ms. Halligan's nomination. But that does not mean that these issues have gone away. Statistics from the Administrative Office of the U.S. Court show that caseloads on the D.C. Circuit have decreased markedly over the last several years. This decrease is evident in both the total number of appeals filed and the total number of appeals pending. Specifically, the total number of appeals filed decreased by over 14% between 2005, when there were 1,379 appeals filed, and the year 2010, when only 1,178 appeals were filed. The workload decline is also demonstrated in the per panel and per judge statistics. Filings per panel and filings per judge show a decline of nearly 7% during this period. Pending appeals per panel dropped over 9%. When you examine the caseload statistics in relationship to other circuit courts, the D.C. Circuit ranks last in nearly every category. For instance, the D.C. Circuit has the fewest total appeals filed per panel and only half as many appeals filed per panel as the 10th Circuit, which has the second fewest in the country. They have the fewest number of appeals terminated per judge, and again, they have roughly half as many terminations per judge as the second least busy circuit, again, the 10th Circuit. They have the fewest signed written decisions per active judge, with 57. By way of comparison, the Second Circuit has 5 times as many, with 270 per active judge, and the 10th Circuit has roughly 4 times as many, with 240 per judge. They have the fewest total appeals terminated per panel, with 347. By way of comparison, the 11th Circuit had over 4 times as many total appeals terminated in 2010, and that number is 1,574. The 9th Circuit had nearly 4 times as many, and that number is 1,394. And the 2nd and 5th Circuits each had 1,329. Given these statistics, we should be having a discussion on reducing the staffing for this court, not filling a vacancy. This seat is not a judicial emergency. And with our massive debt and deficit, I don't understand why we would be spending our time and resources, particularly on a highly controversial nomination. Given the concerns I have about Ms. Halligan's record on the Second Amendment, the war on terror, and other issues, my concerns regarding her activist judicial philosophy, and the court's low workload, I oppose this nomination. I urge my colleagues to do the same. And I would note in closing a number of organizations expressing their opposition to this nomination. The American Conservative Union, National Rifle Association, Gun Owners of America, Citizens Committee for the Right to Keep and Bear Arms, Committee for Justice, Concerned Women of America, the American Center for Law and Justice, Heritage Action, Liberty Counsel, Family Research Council, Eagle Forum, and there are others. I yield the floor.